Absolutely. I think again, there are no hard and fast rules. I think there are times when the cost-benefit analysis has to be made by the panel. And traditionally, arbitration has always been considered, at least in theory, a less expensive and faster and more streamlined method of dispute resolution. I think when the stakes are mid to high seven figures and up, the distinction between arbitration and litigation becomes harder and harder to define, and you would hope that the arbitration panels will keep in mind the size of the dispute in deciding whether to require one party or the other to spend a tremendous amount of attorney's fees and or even technical consulting fees to retrieve what the other party may think is critical and vital to discovery in that particular arbitration. And I think that many of the arbitrators who may be retired for 10 years or more may or may not fully appreciate the necessity of discovery and thorough discovery of electronically stored information, or conversely, the amount of time and effort that may be required by the party on the receiving end of those requests when the stakes of the dispute may not warrant the attorney's fees and even the outside vendor's fees in retrieving information, especially where many, many people are involved in a particular file. We've seen that one email will surface in the files, electronic files of multiple individuals at the same company. And then each of them may respond. And there can be multiple email chains. As you can imagine, if you use a lot of email, multiple email chains originating from the same email and generating multiple chains involving multiple people, much of which is repetitive. But yet still, if you're doing electronic discovery thoroughly and properly, would be necessary. And in many cases, that kind of discovery is just redundant and extremely expensive. Just to weed out those emails, the duplicates and whatnot, becomes very expensive, very time-consuming, very tedious, and you really don't get a significant benefit from that type of exercise. But it's difficult to control, and if the panel members don't understand, it can easily get out of control, and the costs can spiral and skyrocket out of all proportion to what the issues are in the case. Especially if one party is very aggressive and intent on, maybe as a tactic, driving up costs and making it very difficult and painful for its adversary.